Your barn is an eyesore, and my residents shouldn't have to look at it. That was the first thing Renata Voss ever said to me. No introduction, no hello, just that cold, flat, like she was reading off a checklist. I looked out at my grandfather's barn, built in 1947, still standing, still working. Ma'am, who are you? I'm the HOA president, and I've already filed the enforcement notice. You have 72 hours to respond or the fines start. $250 a day. I didn't raise my voice, didn't need to, because while she was talking, I was doing the math. 6 months. She'd lived next door for 6 months. My family had worked this land since 1931. 550 acres senior water rights, a county plat with my name on it that predates her zip code by 90 years. She had a newsletter printed in Comic Sans. I had a lawyer and something she never saw coming. What would you do the moment someone like this calls you? Where are you watching from? Drop it below. Let me tell you about the land first, because the land is everything in this story. Callaway Ranch sits on 550 acres of high desert scrubland and irrigated pasture, about 40 minutes outside of a mid-sized town in rural Colorado. It's the kind of country where the red clay dust gets baked so deep into the fence posts, it looks like the wood grew that way. Where in the morning before the sun gets high, the whole valley smells like sage and diesel and something older than both. That faint mineral tang of water moving through dry soil that people who grew up somewhere else can never quite identify. But ranchers know the way they know their own heartbeat. My grandfather homesteaded this parcel in 1931. My father drilled the well, poured the original barn foundation, and in 1968 negotiated the county road easement that bisects the southeast corner of the property. I took over at 32 after my father's stroke, and in 26 years of running the cattle operation, through drought, years, commodity crashes, commitments that would make a grown man cry into a crescent wrench, I never had a single unresolved dispute with a neighbor. Not one. I'm 58 now. I did 8 years in the Army Corps of Engineers before coming home to the ranch, which means I know how to read a site plan, keep documentation, and wait people out. Skills that were about to become very relevant. About 4 years ago, a developer named Harlan Briggs carved a 47-lot subdivision out of what used to be the old Petri wheat farm, directly adjacent to my southeast corner. Sun Ridge Estates, 90 acres, 47 houses, the kind of semi-rural subdivision where people move to feel like they're in the country without actually having to do anything the country requires. I'd sold them a gravel access easement through my southeast corridor. Good fences, good neighbors, no drama. That was the idea. Then Renata Voss moved into Lot 12, retired HR director from a Denver suburb, freshly divorced, bought her house cash, drove a pearl white SUV with a bumper sticker that said, "My neighborhood, my rules," which should have been everyone's first warning. But the thing about warning signs is you only recognize them after the fact. Within 4 months, she had founded the Sunridge Estates HOA, gotten herself elected president at a meeting 7 residents attended, 7 out of 47, and started publishing a self-produced newsletter called The Ridge Report, printed in Comic Sans. I cannot stress this enough. Her first move against me was a formal courtesy notice delivered to my mailbox, informing me that my cattle were creating noise and odor disturbances inconsistent with the residential character of the community, and that my barn was an aesthetic blight. The notice cited the Sunridge Estates, CCNRs, a document I had never signed, never seen, and had no legal obligation to ever think about, at the bottom in bold. Failure to comply may result in fines of up to $250 per day. I laughed. Actually laughed. The kind of laugh that rolls out of a man who has pulled cabs at 2 a.m. in January and fixed a blown hydraulic line in a hailstorm. I set the letter on my workbench between a tube of bearing grease and a crescent wrench. Figured it was a misunderstanding. I'd make a call, clear it up. That was my first mistake. Not legally, but emotionally. I underestimated the depth of Renata Voss's commitment to making other people's lives complicated. I picked up the phone and dialed the number at the bottom of the notice. She answered on the first ring, as if she'd been waiting. The call lasted 11 minutes. By the end of it, I understood 3 things with complete clarity. First, Renata Voss was not going to be reasoned with. Second, she had given herself a title, Community Standards Director, which she had apparently invented, and used it with the absolute conviction of someone who believes organizational charts they drew themselves are legally binding. Third, she had a theory. The theory was this: because the gravel access easement I'd granted ran through my southeast corner, and because Sunridge residents used that road every day, that made my property part of the Greater Sunridge Corridor. And the Greater Sunridge Corridor, she informed me pleasantly, fell under HOA jurisdiction. I never signed your CC&Rs. The corridor is defined by use and proximity, not just by paperwork. That's not how property law works. We'll see what our attorney says. 9 days later, the formal notice of violation arrived. I signed for it at the bottom of my driveway on a Tuesday morning. Gravel crunching under my boots, the air already warm and smelling of alfalfa, drying in the field, and that faint upper tang of irrigated soil, baking in the sun. I read it standing right there, because some letters you just know to read the moment they arrive. 3 pages, a $250 per day, fine for the barn, an unauthorized structure inconsistent with community aesthetic standards, $100 a day for the irrigation ditch that had run along that fence line since 1971, which Ranatada had characterized as unauthorized agricultural runoff, and a $75 fine for a gate I'd left open 3 weeks prior, which someone had photographed from the easement road, total going back 30 days, $12,750. I folded the letter, put it in my shirt pocket, and drove into town. 2 hours with a local attorney named Dwight Fastbender, 30 years of Colorado property law. Looked like he'd been left outside to cure in the sun for most of them. He reviewed the CC&Rs in about 90 seconds, asked one question: "Did you sign this?" "No." He set the papers down like they were a mild inconvenience. Then he explained something every property owner in America should know, and almost none of them do. An HOA's authority derives entirely from recorded covenants that attach to specific lots at the time of sale. When you buy a house in an HOA subdivision, you sign documents agreeing to be bound by those covenants. If you never signed anything, the covenants don't apply to you. Full stop. An easement is a property right. It gives someone the legal ability to cross your land for a defined purpose. It does not make you a member of their organization. Granting someone the right to use your driveway doesn't mean they get to tell you what color to paint your house. Takeaway: an HOA can only govern lots whose owners sign the CC&Rs at purchase. An access easement gives neighbors a road, not a rule book over your property. With Dwight's help, I sent a certified letter to Renata and the HOA board. 1 page, polite, precise. Cited the Colorado Momo Interest Ownership Act. Confirmed my parcel was zoned agricultural. Informed them the fines were legally void, and that further communication should go to Dwight Fossbender, Esquire. A reasonable person would have backed down. Renata hired Corbin Taft. Taft was a real estate litigator from Denver. Expensive suit, expensive letterhead. And his response to my 1-page letter was 14 pages, arguing my property could be considered part of the Sunridge community under something he called a good neighbor doctrine theory. Dwight read it, set it down, and said perfectly flat, "Well, somebody's billing by the hour." But what happened next is what really changed things. Renata had figured that out quickly, not by reconsidering her position, but by escalating her tactics. If I wouldn't fold to financial threats, maybe I'd fold to government pressure. She started filing complaints. County Building Department. The Barnes additions from 1994 and 2003 allegedly lacked permits. County Environmental Office. The irrigation ditch was an unlicensed discharge point. Colorado Division of Water Resources. Unauthorized well use. State Agriculture Department. Inhumane livestock overcrowding. In 2 weeks, 4 different government agencies showed up at my ranch. The building inspector arrived on a Wednesday morning while I was checking fence line in the east pasture. The sound of a county truck on a washboard road carries that particular high-pitched complaint of a government spec pickup over corrugations, like something very official is deeply unhappy about the terrain. I heard it from half a mile out and walked back, boots leaving clean prints in the pale dust. The smell of heated sagebrush sharp in the 10 o'clock sun. He looked embarrassed at the gate. "Got a complaint?" "I know. Come on in." He stayed 45 minutes and left satisfied. Here's why. I did not have a barn permit problem. I had 30 years of organized records. My father had kept every permit, every inspection sign-off, every county approval in a fireproof file cabinet in the tack room. In 2019, I digitized all 400 documents onto a hard drive with a cloud backup, the kind of project that feels excessive until the day it saves your ranch. The 1994 edition had a permit. The 2003 hayloft expansion had a permit. The irrigation ditch had a 1971 water rights certificate with a recorded senior priority date and an unchanged diversion amount for 53 consecutive years. That last document stopped the Water Division investigator cold. In Colorado and across most of the American West, water rights operate under the prior appropriation doctrine. First in time, first in right. The person who first put water to beneficial use has the senior right, and senior rights cannot be subordinated to newer claims, regardless of who complains or how loudly. My ditch had been running since 1971. Sunridge Estates was built in 2020. If anyone was going to have a water problem in this valley, it was not going to be the ranch that got there 49 years earlier. In Western states, senior water rights can't be challenged by newer landowners, no matter how persistent their complaints. The livestock welfare officer looked at my herd, looked at the pasture, wrote "no evidence of overcrowding or mistreatment," and drove away. Every single regulatory complaint Ranatada filed hit its target and fell apart. Then Corbin Taft tried something different. He filed a document with the county recorder's office claiming the HOA had a lien interest in my property based on the alleged unpaid fines, which now, with Taft's creative accounting, totaled $47,000. This was not a legitimate lien. It was a cloud on title, a recorded document, even a fraudulent one that shows up in any title search and can complicate a refinancing, a sale, an estate transfer, anything, requiring a clean chain of title. It didn't have to be valid to cause damage. It just had to exist in the public record. Dwight called within an hour of the filing appearing in the county system. She just made a serious mistake. His voice had a different quality, not alarm, not urgency, the particular satisfaction of a man watching an opponent walk into a trap they built themselves. A wrongful lien filed without legal basis creates significant civil liability under Colorado law, and filing it through a potentially defective corporate structure raised the possibility that the liability wasn't just the HOA's. Dwight started drafting. He also had one instruction for me: formal log. Every piece of correspondence, every complaint, every agency, every date, every dismissal. I bought a 3-ring binder in a box of page protectors from the office supply store in town. I labeled it in black permanent marker on the white plastic spine. Meanwhile, Walt Obenhaus had been watching all of this and was angry in the way retired school teachers get angry, thoroughly, systematically, and with good organizational skills. 3 other longtime landowners in the valley had received courtesy notices from the HOA suggesting their properties also fell within the corridor. Walt had started calling them. The circle of people paying attention was getting wider, and Renata had no idea. Renata had tried legal threats. She tried regulatory pressure. Neither had worked. So she went for the one thing that can actually threaten a working ranch: the money. Her first move was to approach Harlan Briggs, the original Sunridge developer. Apparently, she didn't have to work very hard. Briggs had his own grievances with the easement arrangement and saw an opportunity. Together, they began arguing that my cattle operation was violating the spirit of the easement agreement, potentially giving grounds to NJ or revoke the access road. That mattered enormously. The gravel road through my southeast corner was the only practical way in and out of Sunridge Estates. Without it, residents faced a 22-mile detour on a county dirt road through federal grazing land. Renata had found leverage, or so she thought. Then she did something worse. She obtained the name of the bank that held my operating line of credit, the line I used for equipment repairs, seed, the working capital a ranch runs on. She called the commercial lending department and made a complaint suggesting my ranch was under regulatory investigation and facing potential environmental liability. She didn't lie outright. There had been complaints filed technically, but the framing implied a crisis that didn't exist. The loan officer called me on a Thursday afternoon. I took the call sitting on the tailgate of my truck in the equipment yard. Sun hard on the back of my neck, the smell of hydraulic fluid and hot steel all around me, the distant sound of my hired hand cleat running the tractor somewhere past the windbreak. We've received some concerns. We want to make sure everything is in order. My jaw tightened. This was no longer about a barn. This was about my ability to operate. I hung up and called Dwight. Then I pulled the original easement document from the fireproof cabinet and read it carefully for the first time in years. Here's what Ranatata and Harlan Briggs had not read. The easement I'd granted in 2021 was specific in scope, specific in location, specific in purpose. It granted right of passage over a defined 30-foot wide gravel corridor. Nothing else. No restrictions on agricultural operations, no maintenance obligations beyond gravel, upkeep. And this is the part that made Dwight quietly pleased. A clause my father's attorney had originally inserted in the 1968 county road easement. And that I'd carry. D forward out of habit. The easement holder shall not interfere with challenge or petition to restrict the primary agricultural use of the servant estate. Translation: if Sunridge Estates or its HOA took any action to interfere with my ranching operation, they were in breach, which meant I could pursue remedies up to and including revocation of the easement. And if the easement was revoked, there was that 22-mile detour. Takeaway: easement documents are contracts. Language protecting the grantor's agricultural use can be inserted at drafting and enforced like any contract term, including the right to revoke if the holder interferes. The bank situation resolved quickly. I called the VP of Commercial Lending directly, not the loan officer, the VP, and walked him through my regulatory log. Every agency, every outcome, every letter stamped, no violation found. Dwight sent a letter confirming no valid regulatory actions were pending. The bank's concern evaporated in 20 minutes, but Renata had a new card. She circulated a petition through Sunridge Estates, calling for a county commission hearing to discuss incorporation of my ranch into the Sunridge Community Plan, a formal annexation bringing 550 acres of agricultural land under a new regulatory umbrella. 31 of 47 homeowners signed it. She submitted it to the county. The county scheduled a public hearing 8 weeks out. I looked at the calendar on my barn wall, the one from the local feed store with the Angus bull on the cover, and circled the date in red marker. Then I got on the phone with Dwight Walt and a woman named Connie Apprentice, who was president of the Colorado Agricultural Landowners Coalition and who had been watching this situation develop with a particular focus of someone who has seen this exact playbook used on small landowners before. Tell me everything. Connie had a researcher on her staff named Betty, methodical, mild-mannered, the soul of an archivist, combined with the tenacity of a badger working overtime. Connie set Betty on Sunridge Estates. 3 days later, Betty called with something that shifted the entire landscape of the conflict. The HOA had never been properly formed. Colorado, like most states, requires an HOA to file articles of incorporation with the Secretary of State, submit recorded CC and RS with the county, and hold a founding vote meeting that meets quorum requirements under the Colorado Common Interest Ownership Act. Betty pulled all 3 filings and laid them out like a coroner presenting findings. The articles of incorporation existed, but listed an incorrect statutory agent address, a technical defect making them vulnerable to challenge. The CC and RS had been recorded, but the recording date was after 17 of the 47 lots had already sold and closed. 17 homeowners had purchased their properties before the covenants existed and had never agreed to them, and the founding meeting Renata had held it on a Tuesday morning in March. 7 people in attendance, quorum for a 47-lot HOA per the bylaws. Renata had written herself required 25% of homeowners, 12 people, 7 was not 12. I sat with this information at my kitchen table on a Thursday evening, the only light, the overhead fixture, a cup of cold coffee at my elbow, the ranch completely quiet around me. 7 months. 7 months of certified letters and regulatory inspections and a fraudulent lien on land. My family had worked since 1931, and the entity doing all of it had potentially never been legally constituted in the first place. Dwight had been waiting for exactly this. The wrongful lien combined with the defective formation created a legal position that was almost elegant in its completeness. In Colorado, the wrongful recording of a lien that clouds a property title can constitute a violation of Colorado Revised Statutes, Section 38, 35, 201, which carries civil penalties, of not less than $1,000 per violation, plus actual damages, plus attorney fees. If the HOA was improperly formed, Renata had potentially filed that lien as a private individual with no corporate authority. The liability could attach to her personally. Takeaway. Under CRS Section 38201, filing a lien without legal basis exposes the filer to $1,000 per violation penalties, plus damages, and attorney fees. Personally, if the filing entity lacks valid corporate existence, for 7 months, I had been playing defense. Now, for the first time, I had something to go on offense with. Dwight drafted a motion to expunge the fraudulent lien, a formal complaint to the Colorado Secretary of State regarding the defective formation and a notice of easement breach, citing the encroachments Cledit had quietly measured along the corridor. Connie forwarded Betty's research to the Colorado Attorney General's office, which had a small unit tracking HOA formation irregularities. A more common problem in fast-growing Colorado counties than most people realized. 3 days after Betty's call, she found one more thing. Corbin Taft had filed the lien document himself, and she had found through the discovery process that would come later an internal email in which Taft had explicitly noted the quorum defect in the HOA's founding meeting. Renata had replied in 4 words. "File it anyway. He'll fold." I didn't fold. I picked up the phone and called. "Dwight, 8 weeks until the county hearing. Let's use them." My kitchen table became a war room. Dwight drove out every Tuesday evening, declined to bill for the drive time, which told you everything about how he felt about this case. Connie joined by speakerphone from Denver, usually while driving, her voice competing with highway noise and a GPS that had strong opinions about the I-25 into range. Walt came in person, always bringing apple fritters from the bakery in town, arranging documents with the precision of a man who'd spent 40 years grading student papers in alphabetical order. Junebug circled the table looking for crumbs and found none. Cleet attended none of the legal meetings, but contributed in his own way. He'd quietly surveyed the gravel easement corridor with a measuring tape, then presented me with a handwritten note on feed store scratch paper. 2 locations where Sunnage residents had placed decorative boulders and a split-rail fence section that encroached into the easement by 4 feet and 7 feet respectively. Thought you'd want to know. He went back to moving irrigation pipe. He was right. The plan had 4 layers, all running simultaneously, all built on documentation. Layer 1 was the lien challenge. Dwight would file the motion to expune the fraudulent lien in district court, citing the HOA's defective corporate formation and the wrongful lien statute. He'd simultaneously petition for attorney fees and the statutory $1,000 per violation penalty. The motion was drafted and ready, but Dwight advised holding it until the week before the county hearing for maximum timing impact. Let it land when Renata was already under pressure. Layer 2 was the Secretary of State complaint. Connie's organization formally submitted the formation defect documentation, the quorum failure, the incorrect statutory agent address, the post-closing CCNR recording to Colorado's Business Division, requesting review of the HOA's corporate status. If the Secretary agreed the entity was improperly formed, it could administratively dissolve the HOA without any court action required. That filing went in immediately. Layer 3 was the easement breach notice. I sent a formal letter, certified return receipt individually addressed to all 47 Sunridge homeowners, not the HOA board, each homeowner personally. The notice identified the encroaching boulders and fence section by precise measurements, formally put every homeowner on notice of the anti-inference clause, gave 30 days to remove the encroachments, and reminded them in language that was scrupulously polite and therefore deeply alarming that continued interference with my agricultural operations constituted grounds for easement revocation. The effect inside Sunridge was immediate. Several homeowners who had been vaguely aware of a dispute with the neighboring rancher suddenly understood clearly and personally that their only practical access road was in play. The Facebook group shifted overnight from 90% Renata cheerleading to a far more complicated conversation. 3 homeowners called me directly. I was polite, brief, and said the same thing each time. I've got no problem with any of you. I've got a problem with a fraudulent lien on my family's land. Layer 4 was the county hearing itself, and this was Connie's domain. She organized 6 speakers, me, Walt, 2 neighboring agricultural landowners, who had also received corridored notices. The county agricultural extension agent, who could speak to my environmental compliance history, and her best recruit, a former Colorado water court judge named Rutherford Haynes, 71 years old, retired, still consulted on land use policy. When Connie described the situation, he said simply, "I'll drive up for that." The centerpiece of the hearing strategy was the simplest thing in the entire plan. Dwight obtained the officially recorded plat map for Sunridge Estates, the county-filed survey that legally defined every boundary of the subdivision. He had it enlarged to 24x36, in and mounted on foam board. The map showed in clean surveyor's lines exactly where Sunridge Estates ended. It showed the 30-foot easement corridor as a thin line through my southeast corner. It showed 550 acres of Callaway Ranch labeled by county tax ID, unambiguously, outside every Sunridge boundary. And it showed that the Sunridge corridor, the jurisdictional invention Renata had been citing for 7 months as the basis for every fine, every complaint, every fraudulent lien, did not exist anywhere in any legal document. Not in the plat, not in the county records, not in any state filing, nowhere. Rutherford Haynes was going to hold that map up at the county hearing, and Renata Voss was going to be sitting in the front row. Renata could feel the ground shifting. She didn't know exactly what was being prepared, but she'd noticed that my name had stopped appearing in HOA correspondence responses, that Connie Apprentice's name had appeared in a county land use filing, and that the Sunridge homeowners were asking questions she wasn't prepared to answer. People who are losing control of a situation often don't respond by reconsidering. They respond by attacking. She called the local newspaper. The Mesa Valley Courier was a twice-weekly paper. Circulation around 4,000, covers school board meetings and agricultural disputes. The reporter Renata reached was Steph Alderman, 27, journalism degree from Colorado State, already fielding interest from Denver papers. Renata gave her a detailed one-sided briefing. A rancher threatening the community's access road, an agricultural operator who refused to meet basic standards. She emailed photos of my barn taken from the easement road, framed carefully to maximize the impression of disorder. Steph called me. This was Renata's miscalculation. She'd assumed I would either refuse to engage, leaving her narrative unchallenged, or say something angry that confirmed her characterization. I didn't, either. I invited Steph out to the ranch. She spent 4 hours there, walked the pasture with her notebook open and recorder running. Met Cleet, who showed her the easement corridor with the measuring tape still in his back pocket. Met Junebug, who contributed nothing journalistically, but made a strong impression. I walked her through the fireproof cabinet, the permits, the water rights certificate, the regulatory dismissal letters and their page protectors, showed her the fraudulent lien filing, showed her Betty's research on the formation defects, and I gave her a copy of the email. File it anyway. He'll fold. We sat at my kitchen table in the late afternoon, the light coming flat and golden through the west window, the distant sound of cattle carrying from beyond the treen. Steph had a journalist's face, carefully neutral, but at the point where she read the email, something shifted in it. Can I keep a copy of this? Keep the whole folder. The story ran the following Thursday. Front page above the fold. Local rancher faces HOA fines despite property being outside subdivision. Records show formation irregularities. Renata was quoted. Corbin Taft declined comment. The piece included a clean explanation of the wrongful lien statute and ran alongside a photograph of the plat map on my kitchen table. By Saturday morning, it had been shared 847 times online. It had a national Reddit thread dedicated to HOA horror stories, and the comments ran for 6 pages. The fracture inside Sunridge Estates became a rupture. 2 board members, a retired engineer named Dale Freiberg and a school teacher named Maureen Ott, posted publicly that they had concerns about the legality of several HOA actions and were seeking independent legal counsel. Renata attempted to remove them from the board via a Facebook post, citing bylaw provisions that didn't exist in the HOA's founding documents. The post was screenshot and shared within the hour. 4 days before the county hearing, Dwight received a call from Miss Corbin Taft. Dwight described it afterward as the sound of a man checking whether the exit is still available. Taft suggested in the vague language attorneys use when they're feeling out settlement without formally offering one, that perhaps both parties could benefit from a resolution that didn't involve further public proceedings. Dwight listened all the way through. Then, my client will be at the hearing Thursday. We look forward to it. He hung up and called me. They blinked. Don't blink back. I spent the 3 days before the hearing not being dramatic. Fed my cattle, checked the irrigation lines, drove the fence line at dusk, the way I'd done 10,000 times. The sky going orange, then pink, then deep purple over the mesa, the smell of cooling sage rising from the pasture floor. I had done everything I could do. Now it was Thursday, the evening before the county hearing. Walt called. Someone had entered the easement corridor after dark and placed a new padlocked gate across the gravel road, blocking vehicle passage entirely. A handwritten sign zip-tied to the gate read, "Road under HOA Maintenance Review. Residents only." I drove out at 9 o'clock, Cleet riding shotgun, the Colorado darkness absolute around us, except for the truck headlights and a faint orange smear of town on the horizon. The night air smelled of cooling gravel and damp sage. I stood at the gate with a flashlight, looked at the padlock, looked at the sign, looked at Cleet. That is the single dumbest thing she has done yet. Here's why. The gate wasn't on Sunridge property. It was on my land, specifically on the easement corridor, which was my property encumbered by an access right, not the other way around. You cannot place a physical lock on someone else's land without their permission. It wasn't just an easement breach. Depending on the circumstances, it was potentially criminal interference with a ordered right-of-way. I called Dwight at 9:15 p.m. He answered immediately. Photograph everything. Get a timestamp. Then call the county sheriff's non-emergency line and report an obstruction of a recorded easement. Cleet photographed the gate, the padlock, the sign, the tire tracks, and his phone screen showing the timestamp. I called the sheriff's line. The deputy who responded, 12-year veteran, calm and methodical, reviewed the easement document I'd started carrying in my truck, confirmed the gate was within the recorded corridor, and left a notice stating the obstruction was to be removed by 7 a.m. or she'd return with bolt cutters. The gate was gone before sunrise. I photographed its absence for the record. I arrived at the Mesa County Commissioners meeting room at 8:45 a.m., 45 minutes early. Standard government beige, fluorescent lights, folding tables, the faint institutional smell of carpet cleaner and recycled air. By 9:15, it was standing room only. The courier story had done its work. Ranchers from 3 adjacent valleys had driven in. Sunridge homeowners, including Dale Freiberg and Morin, who sat pointedly on the opposite side of the room from the HOA board section. A representative from the Colorado Attorney General's office, Steph Alderman with her recorder, and Rutherford Haynes in a jacket and bolo tie, the plat map under his arm, standing by the window with the calm of a man who has done this before and is not anxious about it. Renata arrived with Corbin Taft at 9:20. She was dressed impeccably. Blazer, clipboard, a folder with color-coded sticky tabs. She looked at the room, and for the first time, something crossed her face. That wasn't confidence, not fear exactly, the expression of a person who planned for one kind of meeting and walked into a different one entirely. She sat in the front row. At 9:30, Dwight had filed the lien expungement motion in District Court, time to drop 1 hour before the hearing. The filing attached Betty's full research, the email, the wrongful lien statute citation, and a formal request for attorney fees. When Taft's phone buzzed during the opening commissioner's remarks, he glanced at the notification. He looked across the room at Dwight. Dwight gave him the polite nod of a man who has done exactly what he said he was going to do. Commissioner Hal Duvall called the meeting to order. Third-term commissioner, 63 years old, ranching family himself. He'd read the courier story. He knew what was in the room. He gave Renata the floor on her petition. She stood, had a prepared statement, got 4 sentences in. Duvall held up one hand. Before we get into community planning arguments, I'd like to hear from the county attorney about the legal basis for this petition. The county attorney, a practical woman named Elise Varga, stood up with a single sheet of paper. She looked briefly at the room, at Haynes, and the foam board at the AG's representative, at the full gallery, and said 5 words that define the next 20 minutes. The petition lacks legal foundation. Elise Vargas spoke with the measured pace of someone who has prepared carefully and is choosing every word for the record. The HOA's petition rested on a jurisdictional claim that it held authority over properties outside its recorded plat boundary. That claim had no basis in Colorado common interest ownership law, and HOA's authority derived from its CC and RS. Those CC and Rs applied to 47 specific lots. My parcel was not among them, had never been part of the subdivision, and had existed as agricultural land for 92 years. The petition was asking the commission to do something the law did not permit. Renata began to stand. Duval held up the same hand. Not yet. Rutherford Haynes asked for 3 minutes. Duval Rutherford Haynes asked for 3 minutes. Duval recognized him by name and title. Haynes walked to the front, set the foam board on the easel, and did what former judges do better than almost anyone. He explained a complicated thing with lethal precision to a room that needed to understand it. He pointed to the plat boundary, the clean surveyor's line defining Sunridge Estates. He pointed to the easement corridor, a thin line threading through my southeast corner. He pointed to Callaway Ranch, labeled in county recorded black and white, unambiguously outside every Sunridge boundary. His voice was unhurried. The room was completely silent. There is no Sunridge corridor. There is no Sunridge corridor. That phrase appears in no county document, no state filing, and no legal instrument of any kind. It was invented, and you cannot build a jurisdictional claim on a phrase that exists only in a newsletter. He didn't need to mention the Comic Sans. 3 people in the gallery laughed anyway. Renata stood for her rebuttal. Said the spirit of the community extended beyond legal boundaries. Said agricultural operations created externalities that affected property values. Said Sunridge residents deserved protection. Ma'am, Duval's voice was flat and final. This commission cannot act on the spirit of anything. We act on statute and recorded documents. The county attorney has advised that this petition is not actionable. The petition is denied. In the 3 seconds of silence that followed, Dwight stood. He addressed the commission. Not Renata introduced himself. Noted his representation of me, and informed the commission that a motion to expugn a wrongful lien had been filed in district court that morning, that a complaint regarding defective HOA formation had been submitted to the Secretary of State, and that his client had documented 14 separate frivolous regulatory complaints over 7 months, none resulting in any finding of violation. Then he turned deliberately, precisely, not toward Renata, but toward Corbin Taft. We will be seeking full attorney fees, costs, and the statutory penalty under Colorado's wrongful lien statute. If counsel for the HOA wishes to discuss resolution, he has my number. The room absorbed this. Stepp's recorder was running. The AG's representative was writing. Dale Freiberg and Morn were looking at their hands with the expression of people who have just watched a car avoid an accident they didn't realize was coming. Several Sunridge homeowners were looking at Renata with something between stunned and actively angry. They'd signed a petition for a woman who had used their access road as a bargaining chip in a personal vendetta, and they were only now fully understanding the scope of it. I watched Renata's face from 3 rows back. I wasn't gloating. I was too tired for gloating, too aware of what 7 months had cost in sleep and stress and hours at the kitchen table. But I watched her face in the fluorescent light of that beige government room as everything she had built, the notices, the fines, the complaints, the lien, the petition, collapsed in front of witnesses, a reporter, and a representative of the state attorney general. The clipboard was still in her lap, the color-coded folder still under her arm. She had come prepared for a fight and walked into an accounting. Taft leaned over and spoke quietly. She shook her head once. He spoke again. She sat very still. Then she stood, gathered her things, and walked out without a word. Outside in the parking lot, the Colorado morning was sharp and clear, and smelled like pine and asphalt warming up. Connie hugged me, which surprised me. Walt shook my hand for a long time. Haynes nodded, the nod of a man who has seen this kind of thing before and is quietly glad it went right. Clee had driven in from the ranch and was leaning against the truck. How'd it go? Good. Good, the hear dropped. Twins this morning. I smiled for the first time in about 2 months. The legal aftermath took several months, but it resolved completely. The district court granted the lien expungement motion. 6 weeks after the hearing, the fraudulent lien was removed from the public record. The court awarded me $14,800 in attorney fees, plus $4,000 in statutory penalties, $1,000 per violation across 4 specific filing instances, because the HOA's corporate status was still under Secretary of State review at the time of judgment, and because the court found the filing had been made with documented knowledge of the formation defect. A portion of the judgment was entered against Renata Voss personally, not just the HOA. The Colorado Secretary of State's office administratively dissolved the Sunridge Estates HOA 3 months after the hearing for failure to meet statutory formation requirements. A legitimately constituted HOA was formed in its place by the actual homeowners, meeting quorum, recording proper covenants, filing correct paperwork. Renata was not involved. Dale Freiberg became the first president. He called to let me know. I thanked him and went back to checking the south fence. Corbin Taft received a formal censure from the Colorado Bar Association for his role in filing a lien he had documented reason to know was baseless. It went on his public record. Renata listed lot 12 7 months after the county hearing. The listing sat for 4 months. She sold at a loss and moved out of state. The pearl white SUV left on a Tuesday morning, and nobody in Sunridge particularly noticed until it wasn't there anymore. I didn't throw a party. That's not my nature. The evening after the court's final ruling came through, I drove the fence line at dusk. Same route, same truck. June bug riding shotgun with her head out the window, ears blown back. The mesa going gold, then pink, then deep purple. The irrigation ditch running clear and cold. The barn standing same as it always stood. I stopped at the east pasture gate and sat there until it was full dark and the stars were out over the Mia. And I thought about my father and my grandfather and the particular satisfaction of a thing being what it is supposed to be. Then I went back to work, the conservation easement. The dispute had crystallized something I'd been avoiding thinking about. What happens to this land after me? I'm 58. No children, a nephew in PBLO who'd visited twice and made clear ranching isn't his future. The land needed a plan that didn't depend on my mortality. I reached out to Colorado Open Lands, a nonprofit land trust, and spent most of the following year placing a voluntary conservation easement on 480 of the 550 acres. The easement permanently prohibited subdivision and development, preserved the agricultural character of the land, and allowed me to continue operating the ranch for the rest of my life, while ensuring it could never become another Sunridge Estates. The remaining 70 acres, the working infrastructure core, stayed fully under my control. Conservation easements also carry significant federal income tax deductions for the value of the development rights donated. My accountant described it as the best thing I'd done for my tax situation in 20 years. A voluntary conservation easement permanently protects agricultural land from development while allowing continued use, and the donated development rights can generate substantial federal tax deductions. The scholarship, as part of the quiet resolution Dwight negotiated in the months after the hearing, a contribution to the county's agricultural education fund was made on behalf of the dissolved HOA's remaining assets. I matched it personally. Together, the contributions established the first Callaway Mesa County Agricultural Scholarship, awarded annually to a graduating senior pursuing a degree in agriculture, environmental science, or rural property law. The first recipient was a 17-year-old from a dryland wheat family, 15 miles north of my ranch. At the ceremony, I shook her hand and said the only thing that felt worth saying: learn the law, know your land, don't let anyone tell you what you own. There are more stories like this one. The conservation easement process introduced me to a whole network of rural landowners fighting their own battles. A water rights ambush in the San Luis Valley, a mineral rights dispute on the Eastern Plains, a county road vacation threatening to landlock the family farm that had been there since the 1880s. We'll be telling more of them. So that's how it landed. Fraudulent lien if punches 18,800 adjustment page. The HOA desk was never legally formed in the first place. Disowned by the state, and ran the woman who called me on a studio morning to tell me my grandfather's barn was an eyesore, her house at a loss, and left the county. I didn't celebrate. I went back to work. Same fence line, same irrigation, same burn, still standing. But hear what I want you to take from this. Not the legal wing, not the number on the judgment it did. She has 7 months of momentum and attorney, and a government officer at my gate. I had reports 30 years of organized, boring I'm sexy documentation in a fireproof cabinet. That's what stop her. You don't fight petty power with anger. You fight it with preparation. Now, I want to hear from you. Have you ever had someone show up an HOA, a neighbor, a local officer, and try to tell you what you can do with something that was yours? Drop it in the comments. Every story in this channel start with someone who thought they were alone in this. If this one hit close to home, like surprise, and share it with someone who needs to hear it. Because knowing your rights isn't just legal advice is the only thing that actually work.